Okay, we're going to have to move on to Social Security and SSI Work Incentive Programs with an emphasis on SSI. SSI is the poverty program, as many of you know. Disability insurance benefits is the regular insurance benefits for people who have been working and requires 20 of 40 hours insurance to be covered, which is the same as 5 out of 10 years. However, as you can see from the slide, between the ages of 21 and 31, someone could be insured with as little as 3 out of 6 quarters. 3 quarters is 18 months, so 18 months out of 3 years. Now, this only applies to younger individuals.
The mic.
Pardon me?
Just talking to the mic.
Oh, this only applies to younger individuals. So it's very common when people say they're on SSI and have started working that they'll actually be concurrently on both programs due to this lower amount of insurance quarters of coverage to be eligible for SSDI, also known as Title II, and also get Medicare in addition to Medi-Cal. So the rules are different for younger individuals in that respect. SSI, is a program that, besides the medical requirements of disability, has non-medical income and resource eligibility requirements. And every year there's a redetermination to make sure someone is neither over-resourced or over-income. The resource level has not changed since 1974, and that is a total of $2,000 in any kind of savings. It could be a savings account, it could be 401k, it could be stocks, bonds, life insurance, for a total of $2,000. Now, if someone has $2,005, let's say for over 2 years, they'll get a notice of overpayment asking that they repay every single check, the total check they received for 2 years, because they've been over-resourced and are not required. And it comes in the mail. It can be appealed, but they are very restrictive. People on SSI must report income, whether earned or unearned. Unearned could be any kind of a gift. It could be an inheritance. It could be someone saying, here's a couple $100, buy yourself food for the next 6 months, or money for clothing, as opposed to giving someone clothing and food. That is, if someone gives cash, it'll be subtracted from their check dollar for dollar. And it wasn't that long ago when they exempted things like pots and pans, clothing, and food. It was countable up to very recently. Now, unearned income, as I said, is anything that's not earned. There always are exceptions, and these rules are sort of complicated. However, for example, on unearned income, for Title II benefits, and again, people can concurrently be on both programs. They may get retroactive SSDI. They will have 9 months to do what's called a spend down. In-kind support and maintenance is very important, because if someone is getting room and board, but let's just say don't have to pay rent in an apartment, and they're also given 100 or 200 for food. The 100 or 200 will be subtracted directly from the check. The point is that they're going to get 1/3 of their check reduced, whether it's room and or board. So if who's ever, maybe it's a relative or parents or child to parents, it's important to know that if you're going to give someone board or a free place to stay, it's not going to cost the SSI recipient any more by also giving them food. As opposed to cash for food, it's going to be the same deduction, the 1/3 in-kind support and maintenance. Now, gifts, I won't spend too much time, but dollar for dollar, it's going to be subtracted. So if someone wants someone to have clothing, give them the clothing. Don't give them $100 or $200 to buy clothing, like on a birthday. Someone may say, here's $500. That is going to be subtracted dollar for dollar from the check. And there are some exceptions, as you can see. Tuition, certain kinds of educational expenses can be set aside for 9 months. And exceptions, most of us would never even think of the value of domestic travel tickets. Domestic meaning as opposed to international. SSI eligibility redetermination procedures every year, but actually it could be every other year. They're a little slow in doing this. They do an eligibility redetermination, and they have someone come into the office, the Social Security DO or field office, with every check account and lease, and they want to make sure they didn't go over the resource limit of $2,000, or that they don't have any income, whether it's earned or unearned. And that's when sometimes they'll be ceased, meaning terminated, and just as often retroactively from whenever they were over-resourced. And there are complications when they didn't know about it. Let's say they're severely disabled and their mother is the payee. I've seen cases where the child, severely disabled, maybe nonverbal autistic, the mother balances the checkbook and it goes over $2,000 to $2,005, and I have to pay back $30,000. In other words, every single check for every month when they were $5 over the $2,000 limit. So it may sound like it's a small amount and this shouldn't happen, but of course it really does happen. The age 18 redetermination is something that happens to every individual upon turning age 18. In other words, the child rules, and that is medical rules, apply for anyone who's not 18 yet. But upon their 18th birthday, they get a notice and they apply the adult rules. Now, children don't work. We have child labor laws. I'm speaking generally. I mean, someone who's 17 may be able to get a job, but Social Security will do a redetermination of eligibility for benefits and at age 18. And the student example where someone could, if they're regularly attending school and not married and meet other requirements, they can continue until they're 25 2 years old. Now, students are in a category where there are exceptions in terms of the numbers of hours a week. It's not enough to sign up for school and not go enough hours. It's not going to work. They must attend at least 8 hours per week. If it's grades 7 through 12, it's 12 hours a week. And during vocational rehabilitation, they must attend 15 hours per week and attend 12 hours per week under other circumstances. Now, it can be, it can be less hours if it's something outside of the beneficiary's control. Let's say they get very sick and they're in the hospital. Now, being in the hospital is not always an excuse, just like being in prison is not an excuse to miss a deadline for appeal. And these sound very restrictive because they are. And the theory beyond, for example, if someone's in prison, they can't miss the 60-day deadline for appeal is because you can mail a letter from prison. So that is not good cause for late filing of an appeal. Now, work reviews, I'm not going to spend much time on because we're focusing on SSI, the poverty program, but CDRs is the common name for medical reviews, continuing disability reviews, and the burden is on Social Security to show there has been improvement, that is, medical improvement. Work reviews over the past several years has increased exponentially, and Congress has told them to keep conducting work reviews, and that gets complicated, but we won't go into it too much on SSDI. On SSI, I'd say the best work incentive rule is what I call the 2-for-1 rule. For every $2 you earn, they will subtract $1 from the check. Now, there's also a $65 pass-through, which means it's not counted at all. And if you look at this chart, you'll see if someone earns $1,665 and they do everything by the month, they'll subtract the pass-through of 65, and then you'll have $1,600 is left. The 2-for-1 rule means the countable earnings are $800, and the half of the earnings, of course, is $800, given they're earning, well, it's $1,665 minus the 65, 2-for-1. It's also noteworthy that someone could get down to 0 very easily, but still be on the rolls. Everything's month to month, and they may get 0, but that doesn't mean the Medi-Cal is going to be simultaneously cut off. Those deadlines work a little differently, and Social Security or SSI does not cease Medi-Cal the same time that the checks stop. And employment supports, there's 3 major kinds. One is IRWEs, impairment-related work expense. Now, to have an IRWE, the beneficiary, him or herself, must pay. Now, let's say it's a job coach or an ILS trainer. ILS trainer is as important as a job coach to a lot of people who would not be able to live independently. Independent living skills trainer. They would not be able to go out, get cash, go to the store, get food, prepare a meal. They would more likely eat cold hot dogs or something. They're extremely important for people with developmental disabilities to survive in any kind of living. Usually it's a shared residence where there may be 5 residents, or even if there's only 2 in an apartment, or even 1. Now, they are deductions, and you should think of it as they're not going to result in the check being less. Other employment supports, employer subsidies, which is not like accommodations, it's different, but it's when somebody gets paid for doing the same work that his or her co-employees are doing, then you can subtract that. It doesn't have to be a relative, but sometimes it's more easy to think about an uncle or an aunt or someone who gives someone a job, but the individual disabled beneficiary does less work for the same pay. Or let's say someone has a panic attack maybe just once a week and has to go somewhere to be by himself for an hour or 2 while he's having the panic attack, and he's not going to be docked in pay. That is called an employer subsidy, and it's the second kind of work incentive. The last kind may be the more common, and that is special conditions. I'm not sure where it is in this in these slides, but page 13.
Slide number? What slide number?
Um,
In the blue bottom? Thank you.
Oh, special conditions are under employment supports. Well, okay, and special conditions is when, for example, I've had a client who was driving a truck making deliveries at night. He could not do that, and his girlfriend was in the truck. First of all, he couldn't navigate by himself. He was having blackouts, and he had help, basically. That is called a special condition, and so whatever his pay was, let's say $2,000, the judge could reduce it, let's say, by half to $1,000. So when you talk about employer subsidies, IRWEs, impairment-related work expense, or special conditions, you're getting the amount down. So if it's Title II, they don't go over the SG amount, which in the year 2018 is $1,180. Once you're at that rate, you're not disabled. Even if you're blind and quadriplegic, you are not disabled if you make that much. For SSI, it's going to make a difference in not reducing your check. So they do apply to both programs. They're very important, even though these rules are sort of complicated. Special conditions, IRWEs, and employer subsidies are important because people get a notice, a 15-day notice, and on the notice it says, we have determined to cease you from your benefits, and you have 15 days to respond, and we're ceasing you retroactively for 168 months, which happens to be 14 years. Now, it could be 12 years, 144 months, and then you have to be able to look into every single job that the individual has had all those years and apply employer subsidies, impairment-related work expense, special conditions, and unsuccessful work attempts, which I'm looking, well, let me just put it this way. Unsuccessful work attempts are not countable, and it can't last over 6 months. So someone tries to work, and it's an unsuccessful work attempt based on disability. And they simplified this. They had one rule from 0 to 3 months and another from 4 to 6. So now it's just from 0 to 6, and it's not countable. Sometimes there's a conflict with that and income averaging, where they average over 12 months your earnings. And that works adversely for the beneficiary, because if it's not countable at all, income averaging, which in some cases helps, will defeat the work incentive benefit of the unsuccessful work attempt. After 6 months, it is no longer rebuttable. So we have here what I'm talking about. UWA's 6 months, simpler now. You don't go 0 to 3 and 4 to 6. It's just up to 6 months. And these concepts, imagine that someone who has severe anxiety, let's just say schizophrenia and or autism and severe depression, multiple suicide attempts, sometimes ideation and attempts, and they get a 15-day notice. It's very difficult for, I would say, most individuals with these kinds of severe disabilities to not lose sleep at night and then apply all these rules.
That's why nobody wants to go to work.
And miss, and not to miss the time for appeal, and then 2 weeks after they get that notice, and you have to be prepared for those attorneys in here when they come into your office and show you the 15-day notice of cessation. You have to be prepared to tell them that in less than 2 weeks, they're going to get a notice of overpayment, computer generated. So if it is 144 months, which equals 12 years, it's going to be, you say, well, it may be $90,000 to $100,000. Now, these people are living month to month, and they're very worried when that happens about being evicted and out on the street, maybe with their cat. That was one of my first clients. It's just a lot of anxiety that's created by this, and let me just move forward to sheltered workshops. I think in a sheltered workshop, not that I think, it's generally not considered under the Social Security definition of substantial gainful activity in work. However, for people on SSI, they do count the earnings in determining the monthly benefit amount. So even though it's a sheltered, let's say it's for people with intellectual disabilities and people who are not capable of working in competitive employment, they are going to be counting the earnings in a sheltered workshop. And if on most of these, at the bottom, you see the regulations section, if anyone really wanted to look it up. Now, another SSI program is the PASS. The PASS, a lot of you may have heard of, the Plan to Achieve Self-Support. A lot of people don't know much about it. It's been around, I guess, for 25 years. Social Security at one point was thinking about putting up posters in their office so maybe people would see that they have such a thing. And that's an income sheltering program. And so it's, if someone is on both programs concurrently, they can shelter the Title II or SSDI money. Their SSI check would go up to the maximum, let's say round number 800. They have to have a realistic vocational plan, and we recommend they see a vocational rehabilitation counselor to sign off. It is not okay just to put down they'll go to college for 10 years and they're going to get, we've had people come into the office and say they want to be an PhD in astrological biology or something that may not lead to a vocation. So, and it is sent to Baltimore for approval. And people really can go to graduate school for a PhD program and under a PASS. So it really can help. And it's not only to shelter Title II money. Let's say someone inherits $50,000 from their grandmother. So that would be put in the sheltered bank account and used towards the vocational program, the PASS, the Plan to Achieve Self-Support. The Ticket to Work has been a largely unsuccessful program, PASS, signed by Clinton in December 1999. It's a little beyond the scope of this, and it's not like a real ticket or a train ticket. It's really a letter, and people could sign up, and it should happen over 2 consecutive 12-month periods. And there's a milestone approach in terms of paying the voc rehab counselor and or agency. And they are looking at the earnings and counting them. They do agree not to do a CDR. That is the medical review where Social Security has the burden of proving there's medical improvement and they're no longer disabled. So Social Security says they won't do those unless they're already scheduled. Then they'll do it. At the same time, in this statute, they have extended from 36 months to around 74 months the Medicare eligibility. So they don't have to worry about health insurance like they used to before around 2004 when these regulations came out. And then after that, there's buy-ins for the rest of your life. So that is significant in terms of health insurance and work incentive rules. The other things which are, relatively speaking, important is expedited reinstatement is relatively new. And if you file an application for EXR, which stands for Expedited Reinstatement, you have to do it within 60 months, which is 5 years, after you've been terminated. However, it has to be based on the same disability for which you were receiving benefits. So if you say it was orthopedic and now it's something psychological, it will not work. Now, one other major problem that happens with EXRs is that the individual is cut off retroactively again. Well, let's say it's just 5 years. They were no longer disabled because of working, let's say, and they went over the amount or other reasons. According to their rules, they can only be reinstated retroactively 1 year or 12 months. So, which means they're going to owe the overpayment for the difference. So that's 4 years or what, 48 months of checks. So they can be ceased, which means terminated for retroactively 5 years and reinstated. They sent it back to the state agency called Disability Determination Services, but they can only reinstate up to 12 months. So the differential is an overpayment, which is still owed. However, all in all, the EXR, expedited reinstatement, is very important. We have plenty of time left for what I have, so I want people to ask questions if they want to. Overpayments I'm going to leave out unless someone has a question. Now, the girl in the blue sweater has a question.
Hi, I want to go back to the past question.
Yes, the past plan.
Is the past plan similar to a special needs trust where you need to have a trustee and it needs to be approved by Social Security, or is it merely just having a vocational specialist sign off on it?
There are two separate things. Now, Social Security does recognize special needs trust. And unlike before, the individual can set one up as opposed to a third party. That's sort of new. But a past plan is not the same. The other thing that's new, and many of you may have heard of, is the ABLE accounts. And you can put in up to $15,000 a year, which is the same as the tax-free gift, and it can go up to $100,000, and it can be spent on anything disability related. Now this, you can open one in any state that has one. California is a little behind. They're saying October 2018. But even if you open one in Florida or Ohio or somewhere, you can open one now and build it up. The limit right now, I believe, is $100,000 in the ABLE accounts. When you consider the SSI resource limitation has never changed. It's $2,000, and it has been since the creation of the program in '74. The ABLE accounts is quite helpful. It's a federal law, but each state administers the ABLE account, and here it's the California treasurer, state treasurer. It's approved by Treasury, the federal Treasury Department, but it is helpful in view of all these things I've been discussing, namely income and resource, non-disability eligibility requirements for SSI, the poverty program. With that, I'm sorry, there is a question from the young lady in the purple shirt.
Regarding the SSI and adult disabled child benefits that they might get from their parents. When their parents retire, I've seen people get knocked off of SSI because it goes too high. And then they lose their Medi-Cal and they're in home support. I understand there's this thing called the Pickle Amendment. I have two questions.
Well,
the first one is,
yeah.
how do you prevent losing the Medi-Cal if your SSI is cut off because of adult disabled child benefits
Well,
from the parent.
DAC, or disabled adult child, is something that people want. So I wouldn't cast it in such a negative way. First of all, you're going to get Medicare, and you're also going to get regular Social Security where you're not subject to these income and resource requirement. And you can get it if your parent is either, like you said, retired, disabled, or dead. And it's something that people want, and if they're eligible, should apply for. In terms of having Medi-Cal also, since I think it was 96, they've had buy-in programs, so they could be on both Medi-Cal and Medicare, but anyone on SSI who can get it on the account of a deceased, disabled, or retired parent definitely should apply. They want that. They want to be on regular Social Security and have Medicare also, in addition to Medicaid or Medi-Cal,
They
as we
lose their
call it.
Medi-Cal, or they have to pay a share of cost Medi-Cal, and they lose their in-home support services if they're getting supported living services, you know. So how do you avoid that? I heard something about a pickle amendment that would...
Well, you know, I've heard the word pickle amendment. I'm not familiar with it, but most people do not want to avoid it. Remember, let's say a parent dies and they inherit $500,000. There are no income and resource limitations, and they can collect their Social Security check and get their Medicare. So I don't know who this is who doesn't want that, who'd rather be on this poverty program. You want the DAC, disabled adult child. It's much more beneficial. There may be an exception to it, but they do have some rules, no surprise. You can't get married if you're on DAC, so when people come in for advice, we talk about an annulment. I mean, like with everything else in Social Security, it's a little bureaucratic, and issues like that come up. People on SSI will and should apply for disabled adult children's benefits. It's very advantageous for them for the reasons I said.
And if you start working and you're on DAC, how does that imply the DAC? Is it the same rules as SSI, or?
No, the work incentive, I've focused on SSI, but on the work incentive rules for Title II, which is DAC, are very different. You get a 9-month trial work period and a 36-month extended period of eligibility, and then on the 46th month, 9 plus 36 is 45, so on the 46 months, the hatchet comes down, and so you can keep your earnings under the SGA amount, which this month in 2018 is $1,180. So, I mean, you can or you can apply what I talked about before, the special circumstances, the impairment-related work expense, the unsuccessful work attempt, and employer subsidies, which apply to both. But generally, you have the 9-month trial work period, then the 36-month extended period of eligibility. And remember, the Medicare does not go away. You have it for 94 months or 7.5 years, approximately, and you can buy in for the rest of your life. So on balance, you don't want to be put back on the poverty program. You want to be on the disabled adult children's program. Or for adult children's.
Any other questions?
I have a question. Oh.
People have questions.
Okay.
So I've been asked by an adult who's used a lot of Medi-Cal services, and he's going to inherit some money pretty soon, and he's worried that he's going to be asked to repay his Medi-Cal expenses. Is that possible?
repay the Medi-Cal, you mean retroactively you're
Yes.
talking about?
Is there a payback on that?
There is, someone mentioned share of costs. There is such thing as a share of costs. I don't really know about that it's retroactive rather than current and future. You always see it is something that's going to happen. I mean, when the share of costs come up, there's the $600 deduction. Let's say someone makes $1,800 and the share of costs could then be as high as $1,200. But no, retroactively, the answer is no, not retroactively.
Good news.
You can get it retroactively, either one, Medicare and or Medi-Cal. You can get it, but you wouldn't have to pay it back retroactively.
There's another question, I think. Was there another person? Any other questions?
Well, there's one more with the young lady in the blue sweater.
Yeah, I'm still on the, if you receive money from an inheritance and Medi-Cal, are you allowed to have CDs, or I don't know, what would a person do with the money to be able to keep Medi-Cal?
Did you say C?
A CD or a 401k, or I don't know, where could you put the money?
A CD or a 401k, and you're talking about someone on SSI?
SSDI,
SSDI, regular Title II.
and they get Medi-Cal.
Well, if they get Medi-Cal, which is a poverty program, the same $2,000 resource rule applies as to SSI. And this is another reason for the DAC thing. You can have millions in the bank with Medicare and SSDI. There are no income and resource eligibility limitations.
Can I ask you what that is, the DAC?
The DAC was a question about a disabled adult child. You get your Social Security, regular, not the poverty program, on the account of another. In this case, it's a parent who is either dead, disabled, or retired.
Okay, I didn't know about that program.
Yes, it's important for people to know about it in the event a parent is one of those three things.
Okay.
And
Thank
that
you.
also explains why most children are on SSI.
I see. Oh, you can only do that if you're on SSI, not SSDI. If the child is on SSDI, they can't use the DAC program?
They can't use the DAC program unless the parent is dead, disabled, or retired.
Right, but I understand the child has to be on SSI in order to be able to qualify for the DAC program.
No.
Oh, okay,
The
okay.
child doesn't have to be on SSI. If there's a disabled individual who's not on SSI and they file an application
I
for
see,
a
I see.
disabled adult child, they could get on it.
Okay, okay. Thank you.
Did Alex have a question?
Yeah, I'm kind of on that program where they tell me that if I'm employed, they'll reduce my Social Security, or if it's in reverse, if I'm not employed, then they increase. I'm trying to get some clarification on that, because I got a little.
If you're unemployed, you said they're going to do what?
Increases benefits.
Increase, but if I'm employed, because right now I'm required to work part-time, they decrease my SSI by,
SSDI, you mean?
yes.
Where that comes from is they're talking theoretically in the future. In other words, the amount of the benefit check is determined by your PIA. PIA is the primary insurance amount, which is determined by your earnings record. So as you earn more money, your checks will go up over time. It's sort of like all the people on SSI who start working, they're on both programs concurrently, and then eventually their SSDI is unearned income and will be subtracted from the SSI, and then the SSI will go to zero. It's sort of the same concept. So if you're earning money by working, and in your example, you will develop the quarters of coverage, and you will concurrently be on both Title II SSDI and Title 16, which is SSI. But they're talking that's how it works in theory and in the future.
Yeah, because
It's not as simple as whoever told you that. It's not that simple.
I know, because the way I was told, it was honestly pretty complicated. I'm like, what?
Well, they weren't explaining it correctly.
I know.
I mean, it's nice to hear that. But you'll find, when we prepared for this seminar, someone said, well, most of our agency's clients are in SSI, but most of those people, once they've worked 18 months, which is just a year and a half, out of the last 3 years, they will not just be on SSI, they will be on both SSI and SSDI, and then there'll come a point where the SSDI goes up, it's subtracted, it's unearned income from the SSI, which will go to zero, and eventually they'll not be on SSI at all. They'll be, switched over. So the preferable program is SSDI and Medicare, and the counties can, through the states, an agreement with the states and the feds, buy into Medi-Cal. Some people don't want that premium taken out of their check. Yes.
Hi, I have 2 questions. The first one is about expedited reinstatement. When
Yes.
the expedited reinstatement is improved, does that also mean the work incentive rules kind of start over?
Well, that's a good question. They start over, but not for 48 months or 2 years. Or 2 years. So there's that waiting period. So as soon as you're reinstated, and that process can take 6 months, so you get temporary payments for up to 6 months, in theory. My client waited 11 months when that program first started, but the point is, before you start the new TWP, trial work period, and EPE, you wait 2 years before they start counting months to use against you to terminate your benefits.
Okay, so just to clarify, your expedited reinstatement is approved, so then 2 years thereafter, assuming there's no work involved over the $840 trigger amount, the trial work period does not start.
It does not start, those 9 months don't start for 2 years.
Okay. That is helpful. The second question I have is in regards to overpayments. So it is my understanding that after you have been suspended or cessated, whatever that word is, you are considered to be overpaid. So if you're going to appeal that overpayment, you're going to file a request for reconsideration. When would be the appropriate time to file for a waiver? Would it be after the...
I recommend people file them both at once. However, they're not going to do the waiver until after they do the request for reconsideration. It will be done in that order, because once you've asked for a waiver, you have admitted the overpayment.
Okay, so this occurs even when you go to ODAR, Administrative Law Judge, and the Appeals Council?
I'm sorry? Just
So we're asking for the request for reconsideration
Yes.
and also the waiver, but say the request for reconsideration, the determination comes back unfavorable.
Well, then you go to the next level.
Which
You
is the
request an
administrative
law judge.
So then what happens to the waiver at that point?
Well, you can have both of them together when you get to the judge. Before him or her will be the appeal, the request, which is the request for hearing before an ALJ. It's the second appeal, and the waiver issue. I mean, if you accept the waiver, you're admitting the overpayment, and they decide to waive it, well, that may be a good thing to take. But to waive something, and I didn't go into that, and we are going to have to stop soon, so this is going to be the last answer. For an overpayment, there are 3 legal questions. Number 1, the fact of the overpayment. Was there an overpayment, and is the amount correct? Number 2 is, was the claimant with or without fault and causing the overpayment? And number 3 is, only if the claimant was found to be without fault in causing the overpayment, should it be waived? And to get it waived, there are only 2 grounds. One is hardship, where their expenses exceed their income, and the other one is general principles of equity and fairness. And all overpayments are handled that way, with those 3 questions.
I'm going to make a suggestion that for people who have questions that didn't get answered for the other speakers, that you submit them to the foundation, and we will try to get back to you. Or else you can contact the individual speakers through their contact information, which should be provided here, and we'll try to help you get answers to questions that were not addressed.
It's a very complicated process, but just remember that folks that are part of our agency and IOCO's agency, we do have benefit specialists on staff, and Department of Rehabilitation has excellent benefit specialists to talk about all this in plain English.
Thank you all very much.
Thank you very much for coming to our seminar. As a reminder, for those attorneys who wish to get continuing education credits, please turn in your evaluations and pick up your certificates at the end of the seminar. If you have any questions or comments on today's seminar, please contact People with Disabilities Foundation 415-931-3070 or info@pwdf.org. Thank you.